What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. And today we are going to be talking more about Karen Reed's civil case, but also how that civil case could twist into criminal court once again for some of the names you guys have heard before. And to talk about that, we're bringing Mark Bederow back to talk all things Karen Reed, maybe a little Turtle Boy too. So if you guys are interested in that, make sure you hit the like button. Let's get into it. Welcome back, Mark. Thanks for joining us.
How you been?
Hey, I'm still here. I'm still here, much to the chagrin of some people, I guess, as are you. And we talked a little off air, and you're coming off, I'll call it a win in the Turtle Boy situation. Yet another special prosecutor goes away as we are all wrapped up in what's happening still in Massachusetts with all of the same parties. You would think after one, maybe two acquittals, depending on who you ask, you think it might be over, but instead it seems like it's just a never-ending saga there with the civil lawsuit, with Aidan Kearney's case, and with potential future charges for Karen and Aidan in the future. So we're still here.
For a couple of years, it sounds like, unless at some point there's a new DA in town and just pulls the plug on this whole circus, which, I think that's a realistic option.
I couldn't imagine continuing forward with this after everything that's happened. And you just told me off the air that, multiple prosecutors have been disqualified or conflicted off or bailed on it, want nothing to do with this, even the entire DA's office potentially because of one of the victims in one of Turtle Boy's cases. I just can't imagine looking at this entirety of everything going on, whether I'm a witness, whether I'm part of the victim's family, whether I'm law enforcement, whether I'm a prosecutor. I would want literally nothing to do with this case. Looking at it from that lens, what do you do if you're a prosecutor in that office and somebody comes to you and says, hey, will you prosecute this Turtle Boy case or will you prosecute this Karen Reed case? Because there may be some future combo witness intimidation charges coming for them.
Well, what you do is you turn around, find the nearest door and run as fast as you can and lock it behind you and never come back. I mean, look, first of all, they couldn't even have somebody in the DA's office handle this because of all the conflicts. As it relates to, Aidan's case, you have a situation where the DA's office recused itself, then dug into the taxpayer coffers, hired a special prosecutor for a couple $100,000 who, we certainly allege did a lot of terrible things in the grand jury, just made a mockery of the process. And ultimately, a judge granted our motion seeking to disqualify him because he made himself a witness. He worked with another partner on the case who, the day after we filed this motion about the first special prosecutor, immediately sought to withdraw. He's gone. And then last week, the recently appointed, or most recent special prosecutor correctly sought to withdraw because he and the lead detective were sued by the alleged victim for purportedly intentionally violating her rights. And then you say, well, is the DA going to appoint a new prosecutor? And the DA has another conflict because the alleged victim also sent a demand letter to the district attorney saying, I'm going to sue you within 6 months if you don't handle this and compensate me. So this is a fiasco with a capital F. And what lawyer would even consider touching this? I mean, this case is like the third rail. I mean, if you touch it, it's just not going to go well.
Yeah. And from a prosecutor's point of view, when you look at a case like that, it's a nightmare. You want nothing to do with it. But sometimes you press forward if a child was injured, a life was ruined, somebody died, you push forward. Even in a case like that with a tough victim that might not be cooperative and it's going to be maybe embarrassing at times. But I don't know all the details of all these cases, so I don't want to speak out of turn. But it seems like it's something not worth moving forward on as a prosecutor. Go ahead.
Yeah, I mean, clearly this is not going well and frankly should have never been prosecuted. But, even if people disagree on that, I mean, read the room. What's going on? All of this stems from Karen Reed, all of this, and she was acquitted, in my view, twice of murders, at least once. I mean, people can agree or disagree about that. And this is the guy who reported on that. And most people believe that something nefarious happened here in terms of that case, that there's a problem with the state police. And you know this because the lead investigator was terminated. He's disgraced. Other people who worked with him have been disciplined. They've been kicked out of the Norfolk DA's office. I mean, there's a giant scandal going on. There'll be more in the civil litigation. But at the end of the day, the murder case was over, and the witnesses who were allegedly intimidated are the people that this man reported about based on public filings, saying that, the defense is alleging that they're involved in some kind of cover-up or something. And clearly that influenced the jury in terms of they believe that. I mean, in the evidence in the courtroom, they believe that, and they acquitted Karen. So what are we doing? We're now going to call these witnesses to say, I was intimidated by a reporter who most of the public thinks got it right. And, we hear reports, and, I may know other things that are not in the media about them potentially seeking further indictments for witness intimidation against one or two of the people that we're talking about, after one of them was already acquitted for murder and the other one's already charged with witness intimidation. I mean, if you live in Massachusetts, in particular in that county, your tax dollars are just being flushed down the drain constantly. And it just apparently continues.
So to me, all of this is a perfect segue into the point of our podcast today, which is talking about the civil case for Karen Reed. And if I'm looking at it from that point of view and I'm prosecuting this civil case for Karen Reed, none of that bothers me. It's like, fine, keep coming, keep bringing it, keep embarrassing yourself, keep spending more taxpayer dollars, keep coming after me, and especially the timing of it, right? So if something new were to come, right, new witness intimidation charges, even a new grand jury, trying to prove it, trying to bring forward after they failed in the past, connecting Karen and Turtle Boy, and then she is now announcing civil charges against a bunch of law enforcement officers and a bunch of witnesses that were testifying for the DA in the case against her. And now all of a sudden they have witness intimidation charges. You and I could never do that, right? We can't do that. If somebody's testifying against us, somebody's suing us, we can't be like, you know what? We're going to bring criminal charges against you, which is why this whole saga is starting to look more and more like they're doing everything they can to get Karen Reed, regardless of what actually happened that night, which is going to be some of the factual scenarios that we get, the civil rights violations that Karen Reed is announcing. We haven't seen the lawsuits yet, that she is filing lawsuits against Proctor, Buchanan, Tully, and then McCabe's, Alberts, et cetera, the people inside 34 Fairview. So in my perspective, that really just looks worse and worse for them and better for Karen Reed in this kind of civil litigation, which is a little different. These 1983 actions are different than, a wrongful death case or car accident or whatever the O'Keefe's have filed against Karen Reed is more your average civil case. So knowing that it's going to be different, it's going to be strange, everything about this case seemingly has been. What did you think about their attempt to consolidate all of this together, handle it with the wrongful death car accident case in state court?
I mean, a little surprised. I mean, I think most people thought, at least initially, that they were going to launch a nuclear federal 1983 suit against certainly the state police. If there was an avenue to drag in the DA's office, which of course is extraordinarily difficult with
almost never, like literally almost never,
all the immunities they get. Although, there's this theory of no training and negligent supervision as it goes to disclosure of exculpatory evidence, and maybe there was an end around, like in a Monell type claim, perhaps. But I mean, I wasn't overly surprised that they did it the way they did last week. I mean, I think there was some discussion about why didn't they just do it, or I mean, I'm not involved in clearly what their thought process is, but I mean, it struck me that the way they did it was, number one, they got it out there, and that was the lead. Let's be honest, right? I mean, the takeaway from the court appearance is all these people are being sued, whatever format, whatever procedural mechanism for it. And, some people believe, well, why not just do it and see what happens? They got it out. And I think they also just kind of put a little, they put it out there to see how the court would respond. And maybe that gives them guidance on, are they going to file it that way, or are they going to file a separate lawsuit? It got a little heated, I guess, with the plaintiff's attorney saying we weren't aware of this. it's kind of hard to believe. Maybe they didn't literally say we're going to do this, but I mean, it seems hard to believe that given what Karen's defense was throughout for the past several years and what they've been alluding to, even in the civil litigation, there's been discussion publicly about possible lawsuits. I mean, I think they had to know this was coming, but I have no problem with the way they handled it. And we'll see if they attempt to drag them in as third parties or whether they have to commence a new lawsuit.
Yeah, I have no problem with them doing it, but I also, from the plaintiff's attorney's point of view, I would not have expected them to do it this way and try and consolidate it into this wrongful death and negligent infliction of emotional distress claim, because it is very unusual. It's not how it would normally be done. This would be normally filed, like we said, as a separate federal lawsuit. I understand the argument of all the facts are inextricably intertwined. And for Karen Reed, this would be much more judicious to handle it this way, but not necessarily for literally anybody else involved. Like for the O'Keefes, this makes it much more difficult. For all of the new Karen Reed defendants that she's suing, it makes it more difficult to come into this case as well. Can you think of what reasons why Karen Reed's team would want to do it this way in state court versus federal court, and then vice versa for the other side?
Well, I mean, if they're able to do it, they're suing these people. So, that's check off the list. We have the actions against them. But I also think their not affirmative defense, like they were using as a term of art in court, but their affirmative strategy.
I like how you said a term of art. That's good.
Yeah. Well, I mean, there was discussion about what do you mean by affirmative? But by them going on, this path, if they're allowed to do it, if they're able to drag, I mean, Proctor is a perfect example into this. Not only are they alleging that he committed all of these civil rights violations and, we should be compensated for all of that, but it goes part and parcel to her defense in the civil action. I mean, if she didn't cause John O'Keefe's death, then she can't be accountable for it, really. I mean, if, for example, if they introduce evidence that, Proctor planted this evidence, it helps prove that he violated her civil rights, but it also destroys the claim against her. I mean, it affirmatively kills the argument that she caused John O'Keefe's death. And if they bring in Brian Higgins and they put out, he had a stronger motive to do this because of his romantic, whatever was going on with Karen and, Jen McCabe and all these lies and the Google search. I mean, they get 2 for 1. They're proving their affirmative claims, but they're also wiping out the plaintiff's claim. So I get it. And I think it does make sense in that regard, but I'll also grant you that it's pretty unusual for a garden variety wrongful death IIED claim to turn into, a 30 defendant crazy trial that could just never end. I get it.
I've had some people reach out to me that are lawyers in the area too and say this judge is good. He's pretty down the middle. Yeah, it's not going to be a Canoni situation. And I say that to say, everybody watching and listening, if they don't get to consolidate this all together in state court, it's not because this judge is biased. That would probably be the more usual ending to this entire situation, that they do end up being removed to federal court or not being able to consolidate together, even if they want to file it in state court or they can file it in federal court. They're going to be able to file these actions somewhere. It's not like they're going to get thrown out, but just brace yourself. If it doesn't end up coming all together, it's not because the judge is biased against Karen Reed.
Yeah, I don't think any reasonable observer who's being honest to the process, who watched that proceeding, whatever side of this coin they favor, could say that the judge was a breath of fresh air, perfect judicial temperament, listened to the parties, clearly informed on what was going on, started early, even a few minutes, which is pretty rare. Wanted to
research.
Yeah, I mean, again, judges, all you can ever ask for is a fair, even-tempered judge, and you win arguments and you lose arguments, but whatever he decides on, if they even file it this way, by the way, they haven't committed to it. I mean,
they don't have to. Just because they said it, they don't have to.
That's right. So they may read the tea leaves and say he doesn't really want this. We'll go another way. We don't know, but I don't think anybody could say that this judge did anything to give any indication that he's biased at all for either side.
A little over a year ago, somebody opened a bank account in my name and I had to jump through all sorts of security hoops to prove I am who I am, to get it closed out. And it was miserable, but I was on notice that my information was out there. So I did a bunch of research trying to figure out who the best cybersecurity company was. And long before Aura was ever a sponsor of our channel, which they are today for this episode, that's who I found, Aura. They make it so easy for you to give them the information that you need for them to track. They give you reports of if your password has been used or leaked, or if you need to change your password. They'll give you examples of secure passwords, or you can pick your own. They make it so easy. Aura is all in one digital security. And if anything does happen, Aura includes $5 million in identity theft insurance protection. And they have US fraud experts ready to help 24/7. Try Aura for free for 14 days at aura.com/lawyeryouknow. In those 2 weeks, you'll discover where your data is being exposed and sold. I had to find out the hard way, so check this out so you don't have to. But I do think you're right. He did give some minor hints at what he thought about it, calling it a novel argument, saying, I guess I'll take a look. Yeah. This is a wrongful death case, he said, I think at some point.
And who wants a monster trial like that with that many people? And how do you even do it logistically? I couldn't tell the size of the courtroom from watching TV, but you know, I mean, it's a logistical nightmare if there's that many people.
Well, they were filling the jury box because Karen Reed had like 10 lawyers there just representing her. Then you have the Waterfall and CF McCarthy's, you have the plaintiff's lawyers, and then if you're going to bring in a Higgins and Albert and McCabe, lawyer for Tully and for Proctor and everybody else, I think, what did they say, 10 more defendants?
Something like that. Although, I mean, I could see the bars getting out of it. I mean, you throw a few dollars.
Oh,
it's a
I would.
Pragmatic solution. I mean, I don't know that the claims against them are all that great or all that compelling. But on the other hand, financially, is it worth it? Who cares? And, and if you're the plaintiff,
with Karen Reed's team, they're not going to have to spend a ton of money litigating it.
Right.
They're going to sit there at the depositions like this probably and take some notes and then move on.
Yeah, but I would expect at some point they leave. And to be honest, I mean, again, I don't know what the thought process of the plaintiffs is, but any money they could get from the bars, I would take it and run, because I think they're going to have a real hard time, again, because of the causation problem, even with the lower standard of proof based on the evidence you've seen at the criminal trial. It's going to be a problem. And it's also very interesting that they sued really early in the process. I mean, before the trial, they filed the claim. And
they thought they were going to get some benefit from that. They just never did. But
now, I mean, if you're the lawyer, I mean, you've got to be nervous, right? I mean, obviously, if Karen gets convicted, raised judicata, I mean, home run, right? Easy.
That's why you do it. You look like a king then. It's easy. You get your money and you move on.
But what's rare about this situation, and obviously an acquittal on a different standard of proof is never a be all end all, because you go so far down to a preponderance. But the problem now is, although Karen's defense team had no burden at the criminal trial, so putting the legality of it aside, but being practical for a minute, they paraded in an army of professional people, engineers, medical professionals, and they kind of proved pretty convincingly, at least with the standards of proof, that they're scientifically and from an engineering standpoint, that what's going to be the plaintiff's theory and what's the prosecution's theory doesn't wash. And, the prosecution in the criminal case gave it their best shot. And let's be honest, they got clobbered in trying to undo the medical and engineering testimony. And they spent what amounts to $500,000 on an engineering firm that made a clown show out of this. And that was the best they could find. So, I mean, what are the O'Keefe's going to do in a civil context? And they're going to have to put forth all the lawyer is, all the resources, hoping for a payday. And I'd be concerned, like as a matter of financial business.
Yeah. I mean, a lot of people don't understand the process of not guilty in criminal court could also be liable in civil court. Yeah. But when we talk about that and legally, and as lawyers, when we look at it, a lot of times, so many defenses, I mean, you could probably talk about this, what percentage of your trials you do nothing as the defense, or you put up one witness or whatever. It's mostly your cross-examination, your arguments, you're showing and highlighting the lack of evidence and the reasonable doubt and the holes, which when you don't put forth a defense at all, as a civil lawyer, you come in and you file that lawsuit, you still feel like you can win. Maybe you feel like you're a better lawyer, or you can argue more things in civil court. Or another big ticket item that can change from criminal court to civil court is usually there's some kind of criminal mens rea in the criminal court that you don't necessarily need to have in the civil court. It can just be negligent. You don't have to say they meant to do it. Maybe you argue it was not intentional, which can be very different than the criminal court. So there are scenarios where there's a not guilty verdict in criminal court and you can still be found civilly liable. This trial was very different. Obviously, it was a preview to what they can put forth in a civil trial because that's more like a civil trial. That's what most of the civil defendants do in our cases is they have their own experts. They make their own argument. They present their own evidence, and then the jury's got to make a decision.
Yeah. And again, what's interesting to me is this is a rare situation for many reasons, but there were two trials. So that's certainly one of them. And the lawsuit was filed in the intermission, meaning they had at least some sort of preview when they decided to file. So they didn't just file a lawsuit. There had to be a collision. There's a busted taillight. There's all these fragments of taillight pieces. Of course, we've got a good claim. They filed it after the first trial. In other words, they knew what the ARCA opinions were. They knew that engineers were going to come in and say, as a matter of engineering, this doesn't make sense. They knew, at least on some level, that the medical examiner for the state was going to not give great testimony to support the prosecution or plaintiff. Again, different burdens of proof, but that general theory. And then by the time the second trial came around and they added other doctors, and you saw what the prosecution put forth, which was not much. I mean, it was finger painting, really, to try to rebut any of this. I mean, I don't know where they're going in proving, even on the preponderance level, that it's more likely than not that there was a collision. And the evidence that would support that, if you're the plaintiff, that's got to come from the state police. That's Proctor and Buchanan. That's the taillight all over the ground. That's Jen McCabe saying, she said, I hit him, even though, every transcript and interview, that's not what she said, which is another strong reason, I think. And if they file papers on this to push these people into the lawsuit, that they'll argue that these people are essentially going to be witnesses anyway for the plaintiff. So why not do this all now? I mean, I think you'll probably see some of that.
Yeah, and that kind of does bring me to, what did you think about who they sued, who they left out? Any surprises to you as far as the list we heard?
I mean, I think the state police people, Proctor, Buchanan, Tully, that's a ground ball.
Right.
The McCabe's and Alberts and Brian Higgins. Yeah, I think that's all a ground ball. Again, from a lawyer's perspective, I think the most interesting one would have been, do they have any kind of theory, an end around just the immunity, which is so hard to get around. It's like you said, it's virtually, not literally impossible, but virtually impossible. But it would have been interesting to see, does the DA's office, Morrissey in his official capacity, get hauled into it? So no, it seems clear to me that those would be the right people if you're going to do this and allege some kind of cover up. I mean, they didn't sue any of the lesser people, if you will, that were inside the house or, at the bars. One could say that the most obvious omission, if you look at it that way, was Colin Albert, only because of, some of the things that have been alleged about him in the past and whatnot. But, he's not there.
So, and yeah, I want to talk about both the things you said. So first we'll start with the state police. Whoa, celebration. So we'll start with the state police. So you noticed that obviously there's nobody from the DA in there, which a lot of people were hoping for, and obviously is very difficult to do. But by suing, assuming they're going to, because all this is just announcements at this point, Proctor, Tully, and Buchanan, and they go through discovery. And you have people like Alan Jackson and these other civil defense lawyers cross-examining these witnesses. That might not be the end. I can't tell you how many times we've started on a case, we go into discovery, we take some depositions, and we're like, oh,
You
They
learn.
are involved.
Yeah.
Okay. Oh, you're pointing it over to this restaurant. We have some dram shop cases like, oh, your employee went there first before they came here with this person, whatever it may be. And you add defendants as you go. Who knows what these guys are going to say, right? Are they going to finally be like, you know what? I'm done getting crucified for this. This prosecutor said, you better do it this way. You have to do it this way, or I'm going to have your job. I'm going to get you terminated. I'm going to get you suspended or moved or whatever they can do. Who knows what's going to come out in discovery?
It's interesting too, because, when they take depositions, the lawyers, the court reporter, the video guy, whatnot, no judge. And obviously there are only certain objections which are appropriate at a deposition. If it's privilege and, you can object all you want to the form, and I don't agree with this, but the bottom line is answer the question. And there's no Judge Canone there to kind of, run interference and issue these rulings about what she deems proper or not. So it's pretty much a free-for-all, with certain limitations, obviously, about what they can ask. And so, the questioning for these people will be, I think, a lot more intensive in a deposition than it would be at a trial. And as you said, God knows where it leads.
Yeah. And, you can't harass, you can't, invade somebody's privacy and things like that. So I expect some objections like that. But generally speaking, it's so broad, especially in civil court. Here we can do depositions and felonies as well. So we can do it in criminal cases at the state level, not at the federal level. But so we have that they didn't have in this criminal case in Massachusetts on the state level, the first and second time around for Karen. So it's going to be the first time they really get to questioning at trial is completely different. The cross-examinations couldn't be more different than what they're going to do at deposition. And in case people don't know, the opposing lawyer. So, Alan Jackson, Karen Reed's team will be taking the deposition of Proctor. It's not like Proctor's lawyer takes the deposition and then Karen's lawyers cross. No, the opposing lawyer is the one that takes the deposition, asks all the open-ended question, takes however much time they need. I don't know if Massachusetts limits the time, takes however much appropriate time they need that's reasonable to ask whatever questions they want. And that's why they call it part of discovery, because depositions are not always used at trial. They help you discover the facts in the case and what other information you may need to get, which leads me to all the publicity, the cameras, the interviews, and everything that everybody's doing. It can get a little more dangerous in a civil case when, you get a lot more information in deposition that, as a lawyer is probably not going to come out at trial. And what are they going to do with that information? How much is going to get reported on? How much is going to get leaked? Is it going to, taint the jury pool? Obviously, at this point, if it's not tainted, I don't know what will, but there are more concerns with that, I think, than a pretty closed off criminal process.
Yeah. And it goes for both sides too.
Yeah.
Cameron can be deposed, which, she had a Fifth Amendment right, which no longer exists because although that's actually not technically true. If they're investigating her, you know what, let me retract that. That may be an unforced error, frankly, by the prosecutor amongst other things. You may very well see that there's an assertion of privilege, a Fifth Amendment privilege. So we'll see.
I would do it just because, Yeah.
No, I would say, you want to do this, then let's do this.
That's why I hate everybody that says, I don't hate everybody. That's why I hate whenever somebody says, oh, anybody that asserts their Fifth Amendment right must be guilty. Oh, if you're talking, then you must be innocent. Or even like Alan Jackson said something like, oh yeah, we had no worries because she was innocent. She had nothing to hide. That's why we let her do these interviews. It's like, just everybody pump the brakes on that, because that's not the only scenario that you do that. And you don't just exercise your Fifth Amendment right if you're guilty. And if I'm Karen Reed, I'm absolutely taking the opportunity to assert it as much as I can based on the open investigation or potential investigation that might be there for witness intimidation charges.
Yeah, no, I wouldn't read into it at all. There's a reason why it's a cherished constitutional right that someone who is innocent or guilty has a right to assert and not incriminate themselves. And just because they assert that right doesn't mean I think I'm going to incriminate myself, but it could be interpreted by a prosecutor or someone else as what they perceive to be proof of guilt. And you have a right not to help them do anything that could convict you. So, you
Especially
see
in Massachusetts, right? We know they'll clip it up and use it however they want to. They'll take one word from this sentence and one word from that. That's the point. That's why you assert the privilege.
Yeah. And it's unfortunate because you've seen some real clown analysis on like Court TV and other places where they talk about, oh my God, he's taking the Fifth, so he's guilty. And they get allegedly real lawyers on to talk about this. And it's just a complete clown show. That is they're constitutional rights. It's part of, the Bill of Rights. It's no different than asserting your right to counsel, your right to free speech, your right to be free from unreasonable searches and seizures. There's nothing wrong with using your, constitutionally given rights to not help them come after you.
Yeah, and we're obviously not including Alan Jackson in that. I was just, it's obvious that he is purposeful in every interview he gives. And, that's what he's highlighting. And the momentum that's helping his client is she is so innocent. We don't care what she says. But I'm just saying you take that further and, it creates this aura of anytime somebody doesn't talk, that means they're guilty. But that he is going to continue to keep the pressure on because it does make a difference in this case. And from my perspective, if you're the defendants, that's one of the main reasons you want this to go to federal court. It's a lot quieter. There are no cameras. Even in most of my experiences, right, it's different depending on the judge. You do not have as much involvement in picking a jury in federal court as you do in state court, especially in civil cases. Like civil cases, they let you roll up your sleeves and get to know everything about these jurors to make sure we get a fair and impartial jury. Federal court, most of the judges I've been, they control it.
Yeah, they do it. For the most part, the judge does it.
And we can submit questions and they may say, thank you, Mr. Tragos, but no, thank you. I'm not going to ask that question.
Yeah, no, it's a different game. I mean, it's more belts and suspenders. Obviously, if this is done in, Plymouth County Superior Court, that's an earthier experience, if you will. You get a little more leeway to, rant and rave and do your thing and whatnot. So, I mean,
it seemed like Jackson didn't know that if there were going to be cameras or not in this. Why was that? It didn't seem like it would be a stretch if the media companies wanted to, that they would let cameras be in this.
I don't know. I mean, again, I certainly share the affliction of not being a Massachusetts lawyer with him. That there's some pretty bizarre procedures and things, and it's a learning process, believe me, on a daily basis. So, I'm not sure, but there are video, obviously. Mm-hmm. So, I think they'll be satisfied. I mean, they certainly are not bashful in shining a light on all of this.
Yeah. And that's a great segue because not only are you not a Massachusetts lawyer like Alan Jackson, but you're primarily a criminal defense lawyer. Some would say just a criminal defense lawyer. Like we joke, I'm just a civil lawyer. So
some real estate, but that's a different story. That's
but you'll handle some civil cases from time to time, right? As most lawyers do. And so what's it like when you're used to being a criminal defense lawyer, which I would say might be the most different kind of lawyer because of the protections you have, the constitutional rights of your client, how your client should be looked at by a judge and a jury. When you step over into the civil realm, what are some of the things you're thinking that are going to be different? What are you, I don't know if worried about is the right word, because Alan Jackson is definitely switching sides, and you can even tell in some of his interviews, some of the verbiage is a little bit different. And I see this firsthand. Like I did it myself, but only a couple years doing criminal. I see it mostly with my dad who did it for 35 years, and we go into criminal court and I'm like, whoa, settle down, cowboy. All right. Let's just chill. Cause we could lose on appeal. It's like, we could lose on appeal in this trial. We don't have to worry about that in criminal cases, but what goes through your mind when you handle that, that Alan Jackson's going to have to deal with in this case?
Well, I mean, it's a little bit more of a free-for-all. I mean, the rules are generally more relaxed in the sense that, you're not a criminal defendant, so the rights are a little different. I mean, like, for example, putting aside whether Karen has a legitimate right to assert a Fifth Amendment privilege because of this, fakakta investigation into more witness intimidation, in the ordinary course, she could be compelled to testify, for example. But with the rules of evidence being different, not so much trying to protect the criminal defendant, I think that also plays to their advantage. So, in the criminal trial, there was all this back and forth about don't mention, the boogeyman. And the boogeyman apparently was the Department of Justice and the FBI. That's all going to come in, in the civil trial. I mean, I don't see any way that the defense, the civil defense, is not going to be allowed to argue that these ARCA witnesses were hired by the FBI. There was all this. Everybody knows she was acquitted. I mean, there's no way to hide this. There's none of that stuff. So, I mean, I
kind of think the opposite of that can be argued too by the law enforcement that, they never filed any charges. So it's where the judge is going to draw the line on what's relevant and what's a jury question and what's not, and what facts can be argued to prove what claims could depend on the claim. So we'll see exactly what comes out about that, but I assume it's going to be more open than the criminal case.
Yeah, I mean, I think certainly they have a right in this context to establish that these experts that we're going to be calling, that are going to basically, win the case for us, were in fact hired by the federal government independently, were equally available to all sides, and reached a conclusion that 1000% supports our position. I mean, I think it would be outrageous not to allow them to elicit that. I mean, whatever the risk of prejudice is, it can be dealt with. And like you said, it can lead to flip it on its head and say, yeah, but nobody was charged. But I'm not sure. I mean, that's a trade I would take if I'm the defense. I mean, I think that's a good fact for Karen's people.
Yeah, I think the other side will try to use it as well. But so anything else, we kind of got off track there a little bit with that, but anything else as far as going from criminal to civil that you'd be thinking about, whether it's in trial or just generally throughout the litigation?
I mean, the burden of proof, right? I mean, everything you do, you have to be more alert. I mean, you do have to prove things, right? You can't, in a criminal trial, like you said, there are certain times you could theoretically take a nap and do nothing. Nobody would do that, literally, but it's different. You have to be more aggressive in proving a case and get a jury to lean on your side of the 50% or whatnot. But I don't know that it affects this case so much, because they were, as you said, so aggressive in the criminal trial. And really, from their standpoint, I mean, it's just a redux. I mean, you just bring back all the medical people, all the ARCA people, whether they're allowed to sue Proctor, Buchanan, McCabe, and all those people. They're still going to have to come in and explain this. And, I don't know that there's very much different to do, because their position is going to be whatever sympathy, which is understandable, you have for the O'Keeffes. She didn't cause any of this. And if she didn't cause any of this, you can't hold her liable for, their pain and suffering over losing a loved one.
Yeah. Yeah. And I think those are all really good considerations and things to think about, and just to see how your mind does have to work a little bit different. But on the civil defense, it's closer to the criminal defense than when you're a plaintiff's lawyer and you're trying to prove things actively as on the civil side, which Alan Jackson and Karen Reed's team is also going to do. But just like Alan Jackson, prosecuted a bunch of cases. So you know what it's like to hold a burden of proof and to prove something. And it's a lower and easier burden of proof. And the switch to that from, having to explain as a prosecutor to the jury beyond a reasonable doubt, and to be fair to the criminal defendant, and you explain how high that burden is, it's so much better to be like, the absolute lowest burden we have in our justice system. It's not even 51%, it's 50.1% is all we have to prove this by. I love explaining that to a jury, but that change can also be interesting.
Yeah, but the problem, I mean, again, if you're the plaintiff, that's the whole thing. I mean, it is such a low standard. But in this very unique case, again, going back to the criminal trial, although they had no burden to prove anything and all they had to do was poke reasonable doubt, as a practical matter, with all the medical and engineering evidence they put in versus what the prosecution put forth, their best effort, which was, a pretty unimpressive expert and the state police. I mean, in a practical way, seems pretty clear to me that the defense did establish, at least by a preponderance, that there was no collision. And to find otherwise would be crediting, in essence, Proctor, Buchanan, challenging the engineering science, challenging the medical science, believing, some of these witnesses who I think have serious credibility problems. And that just seems like a real tough road to get past. And it's interesting because in the civil context too, you have to make business decisions, right? I mean, a prosecutor, bless his heart, the only business decision Brennan had to make was, I'll do this and I'm going to get $500,000, whatever happens, who cares? That's not the case with the plaintiff's lawyer. I mean, you bring the case, and you know this more than me. I mean, they're fronting all of this, right? I mean, assuming there's going to be a payday, and if there's no payday, they're going to lose, a substantial sum of money. And then the issue of lawyers' fees, I don't know if that's going to be an issue here or not. I mean, it becomes risky, and I would be nervous that again, putting aside whatever we're going to get from the bar, that this is a tough case that they have because of what's going on in the criminal case, or what happened in the criminal case. And it's just fascinating to me because they filed so early and with knowledge of what the defense already was for the most part in the first trial. It just seems really risky to me.
Yeah, I mean, I was going to say most, but every single wrongful death case I've ever handled is on contingency fee, so we don't get paid up front. I know there are some firms that have handled it hybrid or partially hourly or whatever. I don't know why you'd ever go to a firm like that, because if they believe in your case,
why would you risk paying out? I mean, if you're the O'Keefe, why would you pay for the right? No, I mean, the reality is, I mean, I don't know. Obviously, I don't know.
Right. I'm sure we don't know what they're doing.
You know, I would imagine that this looked like, you know, a big payday at the time. And, you know, you hope for that. And they front all the expenses and hours and whatnot, hoping there's, you know, a large bucket of money at the end. But if there's not, you know, other than the expenses, I suppose that they could be charged with, you know, the lawyers stand to just eat a lot.
Yeah. And so not only contingency fee, but like you said, easily, I mean, it feels like every case is getting more and more expensive, but they're all six figures in situations like this, at least. And, you know, we heard about what Karen Reed spent on her defense. Just assume plaintiffs are going to have to spend something similar to prove the opposite of that. And that also, in every case we've ever handled that's a wrongful death case like this, comes out of our law firm. We front all of that. You get it reimbursed at the end if you get a settlement amount that covers everything, then you obviously get your fees out of that and your costs reimbursed out of that. But if you go lose, you lose it. And most lawyers don't go after the client for those costs. So it's like you're taking a bet on something you believe in, you think is real. So I would assume that's where these lawyers are. I don't think Alan Jackson or the defense team has very high thoughts of those plaintiffs' lawyers or what they're doing here or what they think they're going to accomplish in this case.
No, I mean, and again, the evidence of that, well, first of all, you see the way they interact with each other, but I mean, it can't be understated. I mean, they filed this claim after the first trial, and, you know, their allegations, as I recall, they don't really track the prosecution theory from the first case and into the second case. And a lot of these witnesses are kind of twisted into knots with all kinds of things. They have to challenge this engineering science. They have to challenge this medical science. And, you know, we heard in the argument for the motion to dismiss, you know, it's one thing for the lawyer to get up there and, you know, bless his heart, he's advocating zealously, that's for sure, saying, you know, she knew what she did and she, you know, she knew she hit him. And, but at the end of the day, you know, that's not evidence, right? The lawyer's opinion of what he may prove down the line is fine, but what is the evidence that Karen Reed knew she did this that you're going to impress a jury with? Is that going to be from Jen McCabe and her 27 different stories to the cops and under oath? Is that going to be what Kerry Roberts says, and that came out at the criminal trial, that she lied in the state grand jury and then told the FBI the truth? I mean, these are your witnesses who are going to establish, you know, I hit him. Michael Proctor, I mean, he's disgraced. Buchanan, I mean, where is the credible evidence that, you know, she knew she hit him and, you know, she engaged in this horrible conduct by lying to the family and doing all this? I don't see it.
So again, the she knew she hit him argument that they made, another unforced error, kind of like when I was talking about in the first trial, the defense maybe bit off a little too much burden that they didn't need to bite off. He's doing the same thing. Like, as a civil lawyer, when you prove these cases, you don't have to prove they meant to. Like I was just talking about, criminal mens rea versus accident negligent. It doesn't matter if she was behind the wheel, whether the tires spun in the snow and that's why she hit John O'Keefe, whether John O'Keefe was walking back towards her and that's why she hit John O'Keefe, or however you want to prove how accidental it was, right? If you can actually prove a collision occurred, that's what you want to prove. The problem is they have this other avenue that they're going after, these intentional and negligent infliction of emotional distress claims that Karen knew exactly what she did and decided to frantically come and wake up John O'Keefe's niece and tell her this big lie just to mess with her and make her miserable and hurt her. And then she calls Turtle Boy and they create this whole fake narrative to hurt everybody else.
So
talk about an unforced error and what discovery that opens up and opening up the potential to now weave in this civil case. And I mean, you can talk about how this is going to affect Turtle Boy's criminal case. You can talk about like what does that open the door to, the fact that they didn't just keep this as a simple car accident that caused the death.
So I mean, look, we filed a motion recently in the criminal case and made reference to this thing called Turtle Boy derangement syndrome, which is a real affliction, apparently, where a lot of people don't like him, obviously, but it can create a lot of visceral reactions that perhaps you might want to keep separate from litigation. I thought referencing all of that and turning this into, this is, like you said, she concocted this story and then used, Aiden as the vessel to put forth the false narrative, and she knew it wasn't true. And this is so cruel, and it's all part of her intent. I agree. It just opens the door to discover so much and turn this into something where the irony is a lot of the criticism that was fostered upon the Karen's team throughout the criminal thing was, these tinfoil hat conspiracies. Well, it's kind of flipped on its head based on some of the argument that you heard from the plaintiff's counsel last week, that this is all some crazy lying conspiracy where they're using this guy to put forth a story. I mean, the reality is they filed a motion. I mean, this isn't our motion that we just filed last week. They filed a motion alleging that the Alberts and McCabe's were involved in all kinds of things. This guy picked it up and wrote with it where apparently the mainstream media didn't, and it became a big story and whatnot. As far as how that plays into the ongoing criminal case, I mean, let's be honest, the witnesses who are going to testify, if there is a trial in his case, the witnesses who would testify against him are the McCabe's, the Alberts, Tully, Buchanan, Proctor. I mean, these names sound familiar from last week. These are all the people who are on the precipice of getting sued by Karen for conspiring to violate civil rights. So, at the time they were to testify in a criminal case with all this stuff, they're going to be, one way or the other, if you take them at face value, they're going to be civil defendants in all of this. So certainly, I mean, does that help us? Of course. I mean, how could that not be, a good thing? Just looking on the outside.
That's something you can literally cross-examine them on. In Turtle Boy's case, like, you're getting sued, right? What are you getting sued for? So you got to make sure you win this case, or else you're going to lose a bunch of money in that case. So that's all part of bias and prejudice. Just like when a victim is suing a defendant, it's like, hey, you got to win this because you got a lot of money on the line here. That's all going to be open in the criminal case as well.
Yep. Yeah. No, again, I'm not sure. I don't understand the thought process, the timing of all of this. Or some of these statements, again, it was said in open court as part of a motion to dismiss, although it has nothing to do with it. But I mean, look, the lawyer for the plaintiff, I mean, he was obviously playing to the audience too. Mm-hmm. Just like some could say that everybody was there, everybody's throwing their shots out and trying to get the story, if you will. So a lot of it, maybe it's just lawyer bluster. It was very emotional. Not something you usually see in arguing a pretty straightforward motion to dismiss about whether, certain family members who are not percipient witnesses and were not involved directly have a right to recover. And it kind of morphs into, there's a conspiracy between, Turtle Boy and Karen Reed to harm them. I mean, I get it. Everybody, it's the first opening salvo. And you can just see how contentious this is going to be.
Yeah. And, to think back to good old Adam Lally, the strategy of just trying to not get into the sideshow, to me, was just the best strategy. It's like, try to just put everybody up there to somewhat say the same thing. So the jury's like, okay, I guess it was snowing. I guess he never came in the house. I get, there was a few facts that just like 50 different witnesses testified to. Even when the Turtle Boy stuff was said, he didn't, hammer it and try to talk about it more and more and all this stuff like the McCabe's and Alberts, I felt like wanted to. And you just be careful what you wish for, because this plaintiff's lawyer is the one saying Turtle Boy's name. I didn't hear anybody on Karen Reed's side saying Turtle Boy's name. The plaintiff's lawyer is the one saying she made all this up. And to me, she knew what she did and still, made up this whole story.
Why?
It defies logic and common sense. Like, jurors are not going to be stupid when they hear those voicemails. You might think Karen Reed hates John O'Keefe. You might think she's mad at John O'Keefe. You definitely don't think that she just went and ended his life and is now trying to cover it up with these psychotic voicemails. Like, that's not what that sounds like to me.
No.
And so that's a problem.
Yeah, I mean, again, they really turned up the heat. They bit off probably more they could chew, that it's not necessary. And you're right. I mean, if the idea here is to, deflate all of this, calm it down, and maybe make it more boring, then I think all would agree that, Adam Lally is like a perfect choice from Central Casting to do that. I mean, if you're looking to like vacuum suck out the life of a case that's a little
probably
dramatic.
What I would do with what's on the other side, that's probably what I would do. Because if you can just simplify this to judge, it's a car accident. We're just talking about a car accident. That's it. We do not want to get into all this other crap.
They want to
say that.
It's ironic to me. I don't even know what it means, but there was so much criticism about these Looney Tunes on the defense side who are alleging this mass tinfoil hat conspiracy. And now you have the plaintiff coming in and saying that this is really a conspiracy amongst these people to harm this family. Right away, like you said, like literally within, I'm going to horrify this poor child who's been through living hell, by the way, with her personal family life. I mean, that's just a bridge too far. And why would you do that?
I mean, that's probably, that could be worse than hitting somebody with a car. If that's what you want to go do to that child that night, is just, you would have to be a sadistic, psychotic individual.
You would have to be one sick person to literally at that point in time have the thought process, I just killed him, and now I'm going to go tell, the child that he was hit by a plow or he's dead, and it's my intent to cause her, emotional suffering. I mean, you'd have to be sadistic beyond descriptive words to do, if that's the case. That just seems a bridge too far for a jury.
And people like that exist, and you can prove that in certain cases. And usually you have a lot more that indicates exactly what type of person they are. Well, yeah, you have that in this case.
You have not just, we think. And, again, maybe again, it was just blustering for the cameras. But I mean, if that's the theory going forward, that probably doesn't end well.
And now speaking of just lawyer strategy, and we talked about how the plaintiffs, if we were them, we'd probably just simplify it into a car accident or not take the case at all, of course. But if we did, not do all the sideshow stuff. But as the defense, when we're looking, and I'll have you back on to talk about when they actually file the lawsuit, we see the facts, we see what claims, because there's a bunch of different claims they could potentially bring and facts they could marry to those claims. But you mentioned that Colin Albert was not on the list. He still could be somebody that's sued, but was not on the list mentioned in court. And in an interview on the courthouse steps, basically right after the civil hearing, they were asked the question, I think Cedric, is that Cedrickson is his last name? I can't remember the other defense.
I think Selickson's his name.
Selickson. Yeah. So he was asked, no, Colin Albert, are you guys going to prove who actually killed John O'Keefe? He kind of gave a non-answer, but also kind of said no. Maybe that's why Colin Albert is not on the list, because a lot of people think maybe it was him. Maybe they're just not trying to prove actually who did it, but instead that there was a conspiracy to pin it on Karen Reed. Can you talk a little bit about the difference and why lawyers might take that strategy as opposed to, we're going to prove it was Colin Albert, or we're going to prove it was Brian Higgins, and by proving it's Brian Higgins, it proves it was not Karen Reed? What's the difference in kind of that analysis?
Why take on a burden that you need not meet and run the risk of a jury thinking differently, as opposed to, can they establish that Karen Reed hit him by a preponderance of the evidence? If they can't, they lose. I mean, she didn't do anything. You can't hold her liable. And the reality is there is in my view, overwhelming evidence of credible proof that there was no collision. And that's based on science and engineering. I mean, I accept that, but that does not translate to what happened. But if they can convince the jury, like they did in the criminal case, in a different way, different burden of proof, no burden of proof, we all understand that. But if they can convince the civil jury that there's not a preponderance of the evidence that Karen Reed did it, we think that there is a good faith basis that these people might have done something. That still helps prove your point, but you're not taking on that extra step of confusing the jury and making them reach a decision. And some people think that was one of the problems that happened at the first criminal trial. I mean, some of the people believe that they did bite off more about, we'll tell you what happened, and that might have sent the jury, the first jury, sideways a little bit in trying to solve the crime, rather than
which side's right.
the existence of reasonable doubt. So I think that the defense strategy, of course, I don't think they should try to prove what happened. Now, look, if you had a videotape of somebody either admitting killing John O'Keefe or a video of a different car running him over, yeah, go all in, clearly.
Sure.
But I mean, you know what? The reason you haul Brian Higgins in is because, look, there's a lot of weird things. You don't have to prove it, but you know, Higgins is doing something at that bar 30 minutes before John O'Keefe is allegedly killed. There is a conflict between Higgins and O'Keefe. There are weird text messages between Higgins and Karen Reed, including that night, and between Higgins and John O'Keefe that night. Higgins goes to the police precinct doing weird things at 1:30 in the morning. He's making weird phone calls. He does weird things with his phone. They're going to put all that out there, but that doesn't mean they have to say it proves he did it, but it certainly supports their claim on top of the other evidence that by a preponderance, Karen didn't. And you know what? This guy, there's more evidence against this guy than there even is against Karen, would be their argument.
Yeah. And that's from the civil defense side, and even from their plaintiff's cases, Reed as the plaintiff, in the claims that are going to be coming, you still don't have to prove who did it. And even to win, even when you do have a burden of proof, to win the claims we think are coming, you just have to prove that her civil rights were violated, that there was a conspiracy, either, you know, planted evidence, cover-ups, lying, misreporting things, putting wrong addresses on purpose, not putting what people actually said in your police reports and your police interviews, trying to muck it up on the stand, making sure you force in that you were harassed, even though you knew you weren't supposed to. All of those things, I would think, because that is something you can use. And you can say all of that, but just like a criminal case, you do not have to prove motive. You don't have to prove the McCabe's covered it up because the McCabe's did it. You don't have to prove Proctor covered it up because Proctor did it. You just have to prove they covered it up. They violated her rights, whether it was because they wanted to pin it on the girl, pin it on Karen Reed, whether they wanted to protect one of their friends, whether they wanted to misdirect for whatever reason, whether they wanted to just make sure they got somebody because we've got a dead cop and this seemed like the easiest person to get. The motive doesn't matter as much in the entire story of the civil case and what they have to prove there as plaintiffs for Karen Reed. So why say I'm going to prove it was Brian Higgins or Colin Albert if you just don't need to?
Yeah, and I don't think they will. I mean, I didn't see the interview with the lawyer that you're talking about, but that makes perfect sense to me. I mean, why would you bite off more than you need chew? Which I think the plaintiffs were at least previewing they intend to do, although we'll see if they really do it. But there's no need to prove anything other than the preponderance establishes that Karen didn't cause John O'Keefe's death.
Yeah, he didn't go as far as to say, I'm not going to do it, but he said, I can't answer that right now, and we're going to prove Karen Reed didn't do it, something like that. I'm going to pull it up, and we can listen to it. It was like 3 minutes long. Yeah. But I wanted to ask you this as well. So Alan Jackson in this interview as well. Actually, let's just play the interview because I'll save this question here. I'm sure it's in my history somewhere. Because they talk about, here it is. Okay, perfect. Because they also talk about settlement and whether or not there might be a settlement in this case, and depending on how reasonable the other side is and things of that nature. So I want to talk to you a little bit about what a settlement might look like and why they would even say something like that. So let's take a listen here. I'll just let the entire interview play and then we'll talk about it after.
You need whole change in tactic, right?
I think we're a little offensive during the criminal trial.
How does that work?
I need a full back.
Y'all didn't even let her get a blocking back. My Lord, we can move quicker. Alan, can you help me understand what an affirmative claim is? What an affirmative claim is? It's an affirmative claim against the third-party individuals. That's exactly what we intend to bring.
But the idea is to get them combined to save the court time and money.
All the same individuals are involved, so that's exactly right. It's a matter of judicial economy.
You respond to the longer if you do this.
course, because it becomes a bigger case, more voluminous, right? It's a bigger case with more claims, and that's exactly what this case calls for.
How did you determine
the days of Karen Reed being on the defense, right? That's what started today. We're seeking today.
What do you think of the judge say when trying to resolve this? Can you resolve this out of
Every
court?
single civil case should at least have that on the table. Civil cases are built and designed to be resolved if they can be. We'll see. We'll see. It depends on how reasonable the other side
Was that something
is.
that you guys would like to do, though? I mean,
Say it again.
was that something that you guys would like to do, or do you want to make a point?
Anytime there is a civil case, look, civil cases are not about making a point. They're about trying to seek the truth, right? And that's what Karen's going to do with this civil case. We're going to try to get the truth out there. Like I said, the days of her being on the defensive, those days are over.
So you said
And everything
that
that you heard in there was basically parroted. Every single word that you heard in there was basically parroted right from Michael Morrissey, right from the prosecutions. They lifted it right off the prosecution's closing argument. And maybe somebody should check the tapes. Because last time I checked, those arguments were put forward in front of a jury, and the jury spoke very, very loudly. Not guilty, and not just not guilty when the jurors were asked, innocent. Those claims are false, and they were proven false, and they will be proven false again. But in terms of what you just asked, should this case be resolved? We're always open to resolution. We'll see. We'll see. It depends on how reasonable the other side is.
We
got to go.
Damon, did you want to say anything? I mean, you've been sort of point person on this, or?
Well, Ellen says it all as in its perfect way. So, what we're trying to do is make sure that Karen is well defended and that the claims that we have to pursue for her affirmatively are brought in the same proceeding in the most efficient, judicious way so that her day in court is fully and fairly adjudicated.
But if you combine these cases, isn't that unfair to the O'Keefes?
Not at all. Not at all. Part of her defense is that somebody else put her in this situation. And so that's when I said it's not your typical wrongful death action. Karen Reed is in this situation because of the behavior of others. And as Ellen said, she's no longer on the defensive. She's going affirmatively. And we're trying to put all the evidence, all the parties, all the claims in the same proceeding.
How did you decide on who to name in the counterclaim?
I'd love to tell you that, but it's really sort of a litigation strategy point. So unfortunately, I cannot get into sort of discussions behind the scenes.
So do you plan to prove that someone else killed John O'Keefe?
We plan to show that Karen did not.
But that's not the same as proving someone else did.
We're going to let the evidence play out. I'm not able to tell you that yet, but I can tell you that she did not.
How about, can you spell your first and last name for me? Colin?
Sure. Damon, D-A-M-O-N, Seligson, S-E-L-I-G-S-O-N.
Thank you.
All right. So we'll start with what we just heard kind of at the end. What did you think of his answer to that?
It's fine. I mean, we're not going to prove it. The evidence will come out where it does. I mean, I agree in principle with what he's saying in terms of the rationale for lumping all these soon to be sued defendants, whether third party people or not, that it does relate to her actual defense, her affirmative claims against them. Again, whether a judge allows it or not. But I mean, I get the argument. It does make sense. But in terms of him saying, she didn't do this and we'll let the evidence play out in terms of what it shows who may have, I mean, I agree with that. I think that's the right answer. You don't eat more than you need to eat.
Yeah. And, you got to always learn in this game to not say, no, we're absolutely not going to prove who did it. Leave it open. Let the people wonder, let the people listen, let people figure it out on their own.
Yeah. I thought he was fine. I mean, I thought that was a good lawyerly type of giving a little without really giving a lot.
Exactly. Yeah, exactly. And then earlier when Jackson was asked about resolution, he said, we're always open to a resolution depending on how reasonable the other side is. What'd you think of that?
Well, there's other issues with that too. I mean, first of all, if you were to say absolutely, positively not, never, 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 I'm never going to do this, there are ethical rules. I mean, you have to take an offer to a client, even if you know what the answer is. So, on the one hand, it's probably just smart not to say never. On the other hand, well, if they're reasonable, well, what is reasonable? We'll drop the claim and give you an apology. Exactly. I'm sure Alan would find that reasonable, right? But in a practical sense, how can you see a settlement, again, separating Karen from the bars? They are so all in on her innocence. They're going to sue people. They're still saying that, she wants to go on the affirmative. She wants to prove what happened. You never say never. We all know that. But it's hard to envision any scenario in which money goes on behalf of Karen to the O'Keefes for something that she is adamant that she did not do. And we all know 99% of these cases settle and whatever. I mean, I would assume this is the 1%. I mean, notwithstanding saying, well, listen to anything reasonable.
So there's a couple reasons why I think it might not be the 1%.
Okay.
I would love to know what Karen Reed's insurance policy is, like what the limits are of her insurance policy. And that's not something that's like confidential. I'm sure we could find that out if we really wanted to. But the reason that it might not be in the 1% is I don't know these plaintiffs' lawyers, but as you get down the road and as you're spending money and it's this bad of a case, you might not want to try it and you might figure something else out, or they might end up with a second lawyer on the case or something like that.
Yeah. The defense
Correct.
would be the one that I'd be worried about if I'm the plaintiff's lawyer settled.
Yeah, but on the civil side, it works both ways, right? To be that 1%, both sides have to try it bad enough. And in this case, it could be so bad of a case on the plaintiff side that I could see it being part of the 99 with some $1 settlement, or if you'll pay for, our aperture bill for 20 grand from the insurance. And by the way, I've had scenarios like that. Like once in a while, I'll represent somebody individually while there's an insurance company as well. And we have agreed to pay their costs to make them go. My client, usually if they have a huge policy and they're paying me, they have money's not an issue. It's more stress and they just don't want to deal with it. So even if they think they did nothing wrong, which is not to the level of Karen Reed, obviously, and that we make it clear in the release, we are only paying for costs on this case. No money is going to the client. We are not admitting anything. We did nothing wrong, whatever in the release, but still there's money exchanging hands and the case goes away. So you can get creative in settlements in civil cases.
You can. And I just can't imagine, again, and we don't know, we're not parties,
Sure.
But fashioning that language to satisfy the defense, given where they are and given how successful they've been, given the very impressive narrative that they have, given the level of attorney they have, given what probably is not a winning case, dollars aside, it's just hard for me to fathom, at least at this point, that the defense gives an inch at all, that they want complete and absolute annihilation in terms of victory. Like, we are right. I didn't do this. I'm not giving, I hate to get all Godfather, but you can get all Godfather too. And you can have my offer now, Senator. My offer is this, nothing. Right. I mean, that's what it feels like. And notwithstanding the correct lawyerly statement to say it's the early stages of the game, we don't have to talk about this. But also, if they sue these other parties, that's a complicating factor on what the plaintiff would want to do. And because these people could get lumped into that. I mean, are they going to demand that you drop those? I mean, it's so convoluted, so many moving parts. It feels to me that Karen, who, I mean, she's tough. I know this personally, right? I mean, she is tough, steely, and determined. And she has lawyers who are the same way. Okay, we all know this. And I just picture them going full bore, giving nothing, and looking at an exit strategy for the plaintiff that has two options: complete capitulation, drop it, or try it, if you will, and lose. I mean, I just feel, at least right now, that's where it is. But, you never say never, of course.
Yeah. And you mentioned making deals potentially with like, okay, we'll drop the suits against Proctor and Tully and the Alberts and McCabe's if you drop this case against Karen. Theoretically, you could work that in even if they're not all consolidated into one case, because again, it's civil action and you're making the decisions. But you can't do stuff like, drop the case against Turtle Boy or don't investigate Karen criminally for witness intimidation or Turtle Boy or whatever. You can't mix that because even if you're the victim, you don't control that. The prosecutors and law enforcement and, special prosecutors are the ones controlling that. So you can't really mix that, although you can do a lot of things in the civil cases. To me, I've got a lot of friends that are, some of the best PI lawyers, class action lawyers, billion-dollar verdicts and settlements, hundreds of millions of dollars. And they still, and me and my dad will hang out with them and whatever. And they'll be like, I just can't imagine what it's got to be like to stand next to somebody who could be going to prison for the rest of their life or be getting the needle or whatever. They're like, the sweat that you guys have in those cases is so different. And sitting on both sides, it is so different. It's almost calming when it's, quote unquote, just money. There are people that lost lives and horrible things that happen to people. And I don't mean to diminish that in any way possible, but to illustrate what Karen Reed and Alan Jackson and the team that was there for the defense side, what they were standing there and sweating over while Karen Reed, for something that they truly believe she's innocent of, because that's another scary element as a criminal defense lawyer, truly believing your client is innocent, waiting to see if the jury is going to send her to prison for the rest of her life versus she could lose $1 million that, she doesn't have at this point. It's just not the same.
It's not the same. And again, having been around people facing life in prison, charged with the worst crimes, different people react differently during these stressful processes. Some of these people understandably shrivel up into a ball and just say, figure it out. And I don't even want to talk to you that much because it's too stressful. Other people are involved, but they're just, they don't really want to know, or it's hard to have conversations. What I can tell you is, obviously Karen's facing life in prison, charged with murder. On top of all that, every move she makes is in the public eye. I mean, you can't go out without having cameras and this. I mean, there's no privacy. And I can tell you, in 20 something years, almost 30 years doing this, the way, having been around her during this process and the way she handles this, her steeliness, her toughness, it's remarkable. I mean, in just the most stressful of conditions, her willingness to focus and fight, it was off the charts. And now, like you said, she won that battle. And this, I don't want to call it like you said, diminish it and just say you're playing with house money, but you're playing with house money. I mean, she's not going to prison over this. She's already been called the worst things imaginable. She's been accused of terrible things. There isn't going to be any new mystery evidence that's going to make her look worse than they've already said about her. And, she has incredible lawyers around her. She certainly, has a lot of evidence on her side. I think she's only going to be steelier and even more emboldened to fight.
Yeah, and most of the time, what this judge said is what I'll hear in mediations, kind of like the mediator spiel at the opening, to tell them, there's all this bad stuff that's going to happen in the future. Are you sure you want to do it? Or you could get a guaranteed settlement finality today, which most of my clients, especially if we're dealing with wrongful death claims, this is the worst thing that's ever happened to them in their life. And so they're dealing with it and they're looking ahead like, do I want to do this for 2 more years? And then if I go in and I appeal, do I want to be this stressed out? As a defense, do I want to spend all this money? Am I going to do X, Y, and Z? Karen Reed has already been through much worse. She knows exactly what it's like to litigate a case for multiple years, except to have worse hanging over her head than money. And she's beaten it and she's won. That doesn't mean it makes it easier or less stressful, but she, more than most clients, fully understands what she's getting into at this point. And I don't think that spiel is going to, and I don't say work like it's a trick. It's legitimate. Most clients should settle their cases. Clients should not have this hanging over their head for 7 years. That's not how the justice system is supposed to be set up. So you should settle it. You should be there in good faith and negotiate it. I don't think the spiel is going to work on Karen Reed.
No, and the other thing is this. You have a lot of clients, and I mean, I've represented them all, the totally guilty, the black and white shades of things that may be true or untrue, and the worst kind of client to represent at all. The actually innocent who could go to prison on your watch. And, that's a horrible burden for any lawyer. It's a blessing and a curse to have a client like that for all those reasons. But those are the clients usually who, when it's all over, the famous line, like, what do I do to get my reputation back? Not everybody cares about that. Okay. But let's assume she does. And I don't know to what level, but, she's been raked through the coals. And if There are certain people, though, who say, I don't care. I'm not being smeared with this. I'm going to clear my name. And if that's the goal of the exercise, what she's doing, the only way to do that is to fight through this and expose it all and not settle. Because the reality is perception can be reality to many people. Even if they gave up $1, crafted language of no admission of this, if there's any kind of settlement, a voluntary settlement, there's going to be a certain segment of people who are going to say, oh, that's because of this. Now, again, not everybody would care about that. I don't want to pay money. I don't need this aggravation. But if somebody is out there to clear their name, that factors in. And I mean, that feels like what they're doing.
Yeah, no, I agree. And I would be surprised if there was a settlement, but a lot of civil cases settle. So it's always just kind of balancing it. And I do think the more I think about the facts, I could understand why a judge would let this into state court. I think it would be very unusual. So we'll have to wait and kind of see what the claims are and how they put the facts to the claims. But I appreciate you coming on, hanging out for a while, talking through this stuff. It's really interesting. The case and the saga that never ends. I know you're working hard on Turtle Boy's multiple cases. So good luck on those. What would you say?
Never ending.
Yeah, it really feels like it's never ending, but I always appreciate you spending some time coming and hanging out with me. So until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.